Good morning. It looks to me like most of us have gotten on here. We might have a few stragglers still coming in. Thanks for joining us. My name is Patricia Scott. I'm a partner in our Lansing Foster Swift office. And today we have Alicia Birach, who's a partner in our Southfield office, and she has practiced at Foster Swift for 11 years. I know she doesn't look that old, so she could have been with us that long, but she has. Her practice is focused on assisting clients with workers' compensation claims. She also advises on overlapping no-fault and employment issues. Alicia is going to speak to us this morning about the impact of the coronavirus on Michigan's workers' compensation laws. And so welcome, Alicia. Thank you for joining us. As I've noted in the past, for those of you that maybe haven't been with us, this is going to be recorded. So if you missed something and you want to go back and watch it again, feel free. It'll be on the website. And in addition to that, if you have questions as we're going along this morning, feel free to submit those via the chat. We have quite a few people here, so asking the question verbally might be difficult to do. So go ahead and submit those via the chat, and I'll be monitoring that for us this morning. So with that, we're going to get right at it so that we can get everybody back to work this morning. Alicia, the first question I have for you is how has COVID-19 or how have COVID-19 claims impacted the workers' compensation industry? And I know that's a really big question, so you feel free to try to condense that down for us this morning.
Absolutely. So obviously COVID-19 has had a huge impact on claims across the legal spectrum. But with respect to comp, and this is an issue I've talked on several times, but it's evolving. There's been quite a few significant changes. So, at the beginning of this pandemic, we anticipated that with these stay-at-home orders and having fewer people in the workplace, there would be a significant decrease in the number of claims filed. After we sort of got into this, and now the Workers' Compensation Agency has implemented these telephonic hearings in the absence of in-person hearings. We anticipated that this would sort of cause a slowdown and delay in the processing of claims. And so, when we were sitting here back in March and April and May of 2020, these were the things we were saying we suspected were going to happen. And also at that point, we didn't have a ton of information on how these claims would impact, the rates and the cost of claims. And we sort of now, a year and a half into this, or almost a year and a half into this, rather, have some of this information. And so recently, the Workers' Compensation Agency came out with the statistics for 2020. And what we found after reviewing those statistics is a lot of what we anticipated a year ago did prove to be true. So the contested cases opened in 2020 were 4,587, and that compared to the 5,559 that were opened in 2019. So we're down about 1,000 in terms of contested cases in workers' comp for 2020, which we do think is attributable to the fact that, there are less people working in offices. Also, it's probably in part attributable to the unemployment benefits. We do get dollar for dollar offset for those against wage loss. So that obviously diminishes the value of claims. There's also been other supplemental income coming into people. For instance, if under the CARES Act, if individuals were off for quarantine periods or diagnosis or, care of others. So if they did contract COVID, there was that period where they were paid through their employer. And so they were getting benefits elsewhere. So I think that in some respect led to the decrease in claims. In addition, the decrease in the number of pending contested cases. We also saw the number of claims, claims that are aged rise, which again was not surprising at all. The pending cases that were over 24 months and old in 2020 were 1,724 in 2020 versus 1,023 in 2019. So that's a 700 case increase. And so we're attributing that again to the fact that we are doing these telephonic and Zoom hearings as opposed to the in-person hearings, which is leading to delays in cases, which is not the benefit of either plaintiffs or employers, quite frankly, because these cases are languishing. And so that's a real issue. And what's going to happen when the agencies do reopen to in-person hearings and trials can begin occurring again is there's going to be a bottleneck of aged cases and people kind of fighting to get to the front of the line to get these resolved, so to speak. So we remain hopeful that the agencies will open at some point in 2021. But again, the governor just extended the work from home where you can recommendations this past week, and that goes through October. So, now we're looking at possibly November 1st, because those agencies can't reopen until the state reopens their offices, unfortunately. So, we're always hopeful things will change and the environment in Michigan will start looking better, and we'll get back to these in-person hearings sooner rather than later. But in the interim, these cases are taking much longer to resolve.
In that regard, Alicia, are there currently any executive orders or emergency rules in place which apply to determine whether or not workers' compensation claims are compensable?
So no, not currently. Throughout the duration of the pandemic, there were a number of executive orders and emergency rules which were issued starting back in March. And those created a rebuttable, well, initially an irrebuttable presumption, but that was just for a very short window of time. And then it transitioned to a rebuttable presumption at the end of March. That these COVID response employees, which was defined by these rules, who were diagnosed with COVID-19 suffered from an injury under the act that was compensable. And so this classification of COVID response employees was essentially defined as healthcare workers, paramedics, those in ambulance services, corrections officers, people working in jails, law enforcement, and firefighters. So anything that you sort of think of as a first responder or a healthcare worker was likely covered under that umbrella. And so that presumption was in play, and then it was extended a number of times, including on June 18th through an executive order. And then in October, the Supreme Court came down and basically said any of these EOs after April 30th, 2020 were unconstitutional. So that included the June 18th executive order. And as a result, effective October 2nd, was invalidated. So in response to the fact that this executive order 2021-28 was invalidated and had no continuing legal effect, the deputy director of LEO authored an emergency rule, which was functionally identical to the executive order, and again said that there was a presumption if one of these COVID response employees contracted COVID that it was related and compensable, and that was to remain in effect through March 20th, 2021. And on March 20th, 2021, it expired by its own terms, and it has not been extended by the governor or the deputy director of LEO. And we don't anticipate that it will be. And quite frankly, we think if they tried to do it, it would probably be challenged in court and found unconstitutional at this point, because there's just no law to support an extension of the emergency rule. And obviously, executive orders have already been deemed unconstitutional. So at this point. And so the only way they could put this sort of back into play would be through legislation. And there are several bills pending in the House and Senate right now, Michigan House and Senate, that seek to do just that. But quite frankly, if you look at the political breakdown of the House and Senate, we don't anticipate that they will garner enough support to ultimately get passed. So the only other way they could do this or try to do this, again, quite frankly, rule changes aren't supposed to legislate, and arguably it would be legislation. So, but they could attempt to do a change to the rules, but procedurally that takes over a year to do. So one, we don't think it would be valid, and two, it would take over a year to do. So we don't anticipate any additional presumptions being put into play at this point in time. So there really was only ever the one presumption applying to these COVID response employees, and that expired on March 20th. And it only applied to injuries between March 18th, 2020, well, and by injuries, I mean COVID-19 diagnosis, between March 18th, 2020 and March 20th, 2021. So, now that we are outside of that, time frame, there is no presumption in play.
Okay. And so in talking about claims a little bit, let's do that. Let's talk about claims. And how do employers determine whether a COVID-19 diagnosis is work-related and compensable?
So for cases diagnosed before March 20th, 2021, you would have to look and see what category of employee the person was. If they fell into one of these COVID-19 response employees, it's a much easier task because it's presumed that they are work-related and compensable. The only way to rebut those would be with specific facts of where the person, otherwise contracted COVID. So it's a very, very high standard and, very difficult to overcome. So for claims for COVID response employees before March 20th, 2021, you have to look to that presumption. If you're outside that window and category of, employees, and if you are in that category of, employees, but it's after March 20th, 2021, you're going to analyze it just as you would any other workers' compensation case. And so, you have to look if it arose out of and in the course of the employment. And kind of the first thing that we need to consider when making that determination is, is this an occupational disease or is this a personal injury? And I don't think the answer is going to be the same in every single case. I think it is going to fluctuate depending on the category of employee. So in Michigan, workers' compensation injuries are compensable as either, a personal injury or an occupational disease. Personal injuries specifically, or, usually arise from a specific injury, so a single event injury, versus an occupational disease, which typically occur kind of, more over time out of, circumstances that are peculiar to that certain type of employment. That's always not necessarily always the case. There are circumstances where the courts have determined that something can be an occupational disease, even though it was contracted at a single point, but they're in a category of employment where they're repeatedly exposed to the exposure, and it's peculiar to that specific type of employment, and they could still make the argument for occupational disease. So the reason this is relevant is because it's going to be much more difficult for a claimant to prove compensable injury if it is a personal injury versus an occupational disease. And that's because they're going to have to pinpoint the time of contraction and that it in fact was contracted then and there. And so it won't be sufficient to say, well, I was exposed to Jane Smith and she had, COVID at work, unless they can prove that that is where they got it. It's a very high burden to overcome, and the burden of proof is on the employee, and it's going to be very difficult as a personal injury versus an occupational disease, which it's going to be a little bit easier because they don't have to pinpoint the exact date it was contracted. So when we think of this, a lot of these COVID response employees that we've already talked about, those are the ones that are likely going to fall in the category where people are going to think, okay, this is an occupational disease, where the court's going to come down and say, we're going to analyze this as an occupational disease case. That's further supported by the fact that the executive orders and the emergency rules did specify they were occupational diseases. So I think that's how those will be analyzed. There's also an argument that some of the employees who interact a lot more with the public could try and argue that they should also fall under that category and classification of occupational disease. So for instance, a grocery store cashier who is interacting all day, every day with the public, handling money, talking face to face with people in and out, they're gonna have a stronger argument that, hey, this repeated exposure is more peculiar to my employment than it is to, a person who's working in a law office, behind a desk. And so you're going to have to look at the kind of the role of the employee and what their day-to-day tasks look like and what they're doing and sort of making this determination. So those are the things that we're really going to have to look to. There were a couple of cases in Michigan dealing with an employee in a tuberculosis sanitarium back in 1948. And basically, they kind of held what we were talking about, and that's kind of what we're looking to when we're thinking if we're going to analyze these cases. And basically, they said, if as long as the worker is exposed to conditions of the employment where the risk of contracting the disease is far greater in degree and in a wholly different manner than the public in general, it could be considered an occupational disease. And so that's kind of what we're going to look to. So obviously it's going to be better for employers to make the argument and position themselves to say, hey, this is a personal injury claim. And they have to prove the exact pinpoint of contraction and how they contract it in the employment versus an occupational injury. And if it's an occupational injury, the other thing I should note that is to the benefit of an employer is that occupational diseases exclude diseases that are, ordinary diseases of life. So that are, very common in the public, right? And so COVID-19, considering the number of cases, can arguably be considered an ordinary disease. And so this is another basis you can issue a dispute on. Now, again, when you start getting into these certain areas of employment, like these COVID response employees, where they are facing, interaction with COVID patients day in, day out, they have an argument that could be made that for them, this caveat shouldn't apply because they're being exposed to a far greater degree and a far greater risk than the average person. But again, it gives you a basis to dispute, and the onus is on the employee to prove their case. So as the employer, if it's a personal injury, you can dispute on the basis that it didn't arise out of and in the course of the employment, and the onus is on the employee to show that it did. And as an occupational disease, you could dispute as an ordinary disease of life. And so those are two bases from a causation point. And again, the burden is on the plaintiff to submit the proofs, and they have a very, very, very high burden. And so I think that what we're going to see is for most of these claims, it's going to be extremely difficult for plaintiffs to make their case. Obviously, the difficulty will decrease in certain professions, but I still think across the board, they're going to have a hard time because it is a high burden of proof. There are also things that employers can be doing to sort of mitigate some of their exposure or put themselves in a position if there is a workers' compensation claim, they can point to these things to help show, hey, this isn't something they can track here. And so what we've been advising employers to do is make sure that they have safety plans in place, make sure they're doing return to work plans, outlining the safety procedures and steps being taken to mitigate the risks in the offices or workplace settings. Make sure you're following all local, state, and federal guidelines that are currently in place. Reducing common touch points as much as you possibly can. So that way, if a workers' compensation claim is filed, you can say, well, hey, they're saying they contracted this at work, but we don't have any documented cases of COVID, on site. And even if we did, Sally Sue and Jane Smith didn't work anywhere near one another, and all our, coffee stations and water fountains are closed, so there are no common touch points. And we did A, B, and C, and here's our safety plan proving it. And so that's going to make it more difficult for the plaintiff to show that they, in fact, did contract COVID as a result of their employment.
Yeah, and take those proactive steps. That makes a lot of sense.
Yeah.
And we're running a little bit short on time. We're getting close to the end, but I would like to touch, if we could, on this idea of how COVID-19 has affected other types of claims for employers, namely, this remote work setting. And the idea, you and I have talked about it before, this idea that somebody working at home can still have a workplace claim, so can you talk to us about that a little bit?
Sure, absolutely. So obviously the pandemic has shifted many people away from an office setting and at home to homes. And one of the difficulties that employers face when this occurs is that the work site now becomes the house. And so the risks of the employee's home sort of become, they do become the risks of the workplace. So, what we have to look to is, why, the first question is, why is the employee working from home? Is it at their choice, or are they there? Are they mandated to be there? Do they have a permanent office set up there, or is it, just temporary? Who's directing them to be there? And if, in most cases, it is the employer. They're working at home based on, the employer's policies resulting from the pandemic and some of these orders and recommendations by the governor. And so that likely is enough to say, okay, this is now the work site, and the risks at home, are now the risks of the workplace. So for instance, why is that relevant? Well, when I am in the office at Foster Swift, my dog Gatsby is not lying on the floor. And so I will not trip over her when I, duck to get a coffee or run to go to the bathroom. But if I am, working at home and I, get up from my office chair and walk down the hall, I could trip over the dog. And now there's a question, is that compensable? Because the dog has now become a risk of the workplace. And so that's an issue employers are going to be facing. And a lot of these questions, the answers aren't clearly defined. We do know that if you are doing, anything work related, it would be in the course of the employment, and that includes incidental things and things for personal comfort. So if you have an employee who's working at home and they are thirsty and they run to their sink to get a drink of water and they slip, that's an incidental activity to the employment. It's for employee comfort, and that could be considered compensable, just as it would be if they were working in the office and went to the lunchroom to get, a drink of water. So those are the things we have to look at. It's also more difficult, to control the ergonomics of the workplace. So, you might see some more repetitive strain type injuries from not having these ergonomic setups at home that you would otherwise have in the office. Another difficulty employers are going to face with this is, there's not the benefit of witnesses or of cameras on site. So if, you're in an in-person setting, usually the employee will say, well, John Smith witnessed this incident, or John Smith will say, I worked with, Fred all day and I didn't see him, get hurt and he didn't wince or complain. And so, you have the benefit of those things, which you don't have when the person is working from home. The things that, we should be looking to when we're making these determinations is, what was the employee doing at the time the injury happened? And, was it an actual risk of the employment, and how far of a deviation was it? So when I say a deviation from the employment activities, I mean, if I am sitting here doing this Zoom call with you all this morning, but I'm also riding my Peloton bike, and I, twist my ankle while I'm riding, is that compensable? Because I am doing a work activity this morning, but I'm also riding a Peloton bike that is in my home office. And so is that too great of a deviation? And again, a lot of these questions don't have clear-cut answers, but we definitely are in a position to argue that something like riding a Peloton probably, shouldn't be covered and is too far of a deviation from the employment activity, and that, Foster Swift has not, received any sort of big gain or benefit from me riding this Peloton while doing this conference call, even though the Peloton is a part of my work site, when working from home at this point. And so those are the things we're going to have to look at in the complicated issues that are sort of going to arise as we move forward here with these work from home injuries. And so that's sort of the hard part that, the harder things that employers are now going to face are these at-home risks that have been incorporated to the work site, and how do we dispute them? And I think really it's going to be by looking at how far of a deviation it was from the employment activity. But again, incidental activities such as grabbing a thing of water or running to your printer, which maybe is in a different room in the house than where your office desk is set up, those things will still be considered, in the course of the employment. So.
That makes sense. That makes sense. Are you familiar? Have there been a lot of claims that you know of that have been brought?
Thus far, we're not seeing a ton, but those are going to lag. And so, we're waiting to kind of see how some of the stuff plays out. There was a bit of a backlog at the agency, and some applications have started to sort of roll through in a more consistent fashion over the last month now. And so that's kind of what we're looking at. We have seen some psychiatric claims, secondary to COVID related things. We have seen some COVID claims. And so you're looking at some more workplace like stress related claims. And then, these COVID claims are really starting to roll in. But as far as the work from home, we haven't had a ton at this point, but they are going to present unique and new issues for employers, because previously you weren't having to address something like whether the employee who was walking on their treadmill had a compensable injury, because it just wasn't part of the work site. It wasn't an issue you were facing. So, and again, I mean, when you're working from home, other instances that, we foresee are an employee is taking a work-related phone conference call and they decide to walk around the block while they're doing it, and they slip and fall, on their driveway walking back into the home. Is it compensable? And so these are things that employers, have to think about. And again, having a policy in place is something an employer can do to protect themselves. So if you have a remote work policy stating, no social or recreational or, workout activities while, performing activities of work, or, you delineate some of the do's and don'ts of work from home, and you have a policy on what is expected of these employees, it will provide another layer of protection to these employers. And that's something we're frequently preparing for clients, are these work from home policies, along with the safety policies and return to work policies we spoke about earlier.
Yeah, again, going back to being proactive, that makes perfect sense. Well, thank you so much, Alicia. That's been very informative. And you can contact Alicia if you have any further questions in relation to workers' compensation questions. Like I said, this is recorded and will be on the website. Next month, on the second Wednesday, it will be on May 12th, and we're going to have Amanda Donovshek. Hopefully I said her last name correctly. And she's from our Lansing office, and she's going to talk to us about the basics of women-owned business certification. So that'll be a very interesting topic and a lot to learn on that one as well. So with that, I will let you all get back to your day, and thank you for joining us.